Welcome to Financial Planning Explained. I'm your host, Mike Menninger, certified financial planner, owner and founder of Menninger and Associates Financial Planning. I'm pleased to have a couple of estate attorneys with me that I think very highly of. And we've got Anylise Crouthamel all the way to my right and Doug Kaune in the center. They're both attorneys with Unruh. Is it UTBF? Unruh, Turner, Burke, and Frees. Sorry, Mr. Frees. So anyway, couple of estate attorneys. Quite honestly, I've worked with many estate attorneys during the course of my career. And I've said this to Doug, he's not going to be able to walk out the room. These two stand head and shoulders above any of the estate attorneys that I've worked with in the past. And when I get complex cases, I always refer them to Doug and Anylise. So thank you for coming. The other thing that happened, it was coincidental that we had a meeting last night with clients, and I'm like, man, guess what? I'm going to be meeting with Doug and Anylise tomorrow. I had this long list of questions, and I'm like, well, heck, let's make this an episode, because I can't begin to tell you how many viewers have to run into this particular thing. And so what we're going to be talking about today is asset protection trust. Is that what you'd call them?
Yeah, absolutely.
Right. So Doug and Anylise, thank you very much for joining me.
Thanks, Mike. Thanks for having us.
Thanks,
and
Mike.
thanks for the swag, too.
There you go. So I know you need to get your disclosure out of the way, so go ahead and please do.
We do. We have a little disclaimer. Anything that we're talking about today is purely educational. It is not specific to anyone's particular case. We are not providing you with legal advice. This is information to help make you a more informed consumer of legal services.
There you go. Well done.
Yes,
well done. So thank you very much for joining me. This is great. So as I pointed out to you, and we talked about it for a couple of minutes beforehand, but for the sake of the viewers, I know full well, because I bump into this all the time. Kyle, when you guys walked in, is like, I had a case just like it. And he's talked to you about it a bunch of times, is a lot of elderly people are looking to make decisions to protect their assets. And the protection can be in a variety of different ways. One is for Medicaid, one is for being sued, and just a variety of different things. And we came across a case last night. I wanted to ask you a bunch of questions. So maybe you could take a minute and give me an overview on asset protection trusts that I was talking about.
Sure. I think it's important to understand that there are quite a number of different scenarios where you would use an asset protection trust. And in this particular scenario that you're describing, we would refer to it as a Medicaid asset protection trust, because it is largely being utilized in a situation where we have clients who are concerned about the possibility of needing long-term nursing home care in the future, and they're worried about what the cost associated with that care will mean to their overall estate and how it would affect the assets that they want to leave to their children, to their spouse potentially, and basically wanting to protect the assets that they've built over their lifetime and make sure that they're not completely spent down on that kind of health issue later in life. And so we help them work on a strategy to transfer assets during their lifetime into a specialized trust, which again, we refer to as a Medicaid asset protection trust. And the reason we refer to it that way is that it helps those clients to qualify for Medicaid or medical assistance earlier than they would have had they retained all of those assets in their individual name. So they're basically taking these assets that ordinarily would be vulnerable to the spend down process during the long-term nursing care scenario, and they're moving them early during their lifetime at a point where they feel like they're in relatively good health and they have sufficient time to transfer them and then maybe have good health prior to needing to move to a long-term care facility, because there is a 5-year ineligibility period that's caused by the transfer of assets to the Medicaid Asset Protection Trust. So basically, we're strategizing early in these individuals' lives at a point where they feel like they basically have 5 years of good health, or a combination of good health and maybe financial assets that they've retained in their individual name to get through that period of time, so that 5 years and a day later, everything that they move into that special trust will be protected. And if they need nursing home care after that, those assets in the trust are not vulnerable. So it doesn't matter if it's $15,000 a month, $20,000 a month for a nursing care facility, the assets in that special trust will not be a vulnerable resource that has to be spent down.
Thank you.
Yeah.
So
Dude, that really, the last bit that you said really helps put it in perspective. Like, why would you want to do this planning? The cost of care is exorbitant. I mean, your low end, $10,000 a month, high end, we've seen a lot of clients paying $30,000 a month for that kind of long-term nursing care. So that's really the motivation for a lot of folks.
exactly. And that's a big number. And so we're referencing the discussion we had beforehand. This is very common. So what we have here is a widow who owns the home because her spouse just died. So the spouse left her with an insurance policy, some other assets, and the home. And what I've seen plenty of times before, we've all seen this before, we see good intentions result in unintended consequences. And people saying, well, I want to get the house out of the estate to protect it from Medicaid. And what ends up happening is that they take, let's say, a $700,000 house that they bought 40 years ago for $20,000. They say, let's just gift it to the kids to get it out of the parents' name. What they don't realize they just did is they just created a giant capital gain for their children, because when they gifted to the house to the children, what the mother paid for it, or what the parents paid for it, gets transferred over to the children. Whereas if they died with it, they get the step up in basis where there's no capital gain. So question I have for you here is, let's say in this particular instance, they decide to, can they put the house itself into the trust?
They can. And that issue that you raise is something that we hear all the time. Clients frequently say to us, well, what about just transferring the house to the kids for $1?
Right.
You constantly hear that. And the point that you made related to the tax issues is really important. There's also another really important reason why that might not make good sense. And we were talking about it a little bit before, which is if you transfer that asset to your children and they end up getting divorced, getting sued, have a creditor coming after them, that home now is subject to what's happening in their personal lives. So
Right.
they have this risk as well. And so the intention might be that we've transferred it to the kids, but maybe mom still needs to live there. And now you've subjected this home to this risk. And that's another reason why you might want to transfer that home. And the short answer is yes, you can transfer real estate into this kind of trust. It's a lot of complex variables to consider, one being this capital gains tax issue. We want, in a lot of instances, when somebody has owned the home for a long time, there's tons of appreciation.
Yes.
And so we do want that home to get the step up in basis when somebody passes away. And you can draft these trusts to trigger that includability so that it protects the asset from what's happening in everyone's personal lives, lawsuits, creditors, divorces, and also still get that step up while also protecting it from the long-term care spending.
Interesting.
Yeah.
So on that note, with step up in basis, we did the calculations last evening, and it turns out that if, based on the fact that they got a step up in basis for the spouse that died, then she has a $250,000 exclusion for capital gains because it's her primary residence. If you were to take the property and move it into the irrevocable trust, and she chooses to sell it, does she still get the $250,000 step up or capital gain exclusion if it's in the trust?
I'm smiling about this because it's one of those kind of like things that we nerd out on, which is, yeah, go ahead.
It depends on how you draft the trust. But
Right.
in a scenario like this, we would draft it in a way that allowed her to get basically her cake and eat it too.
That's what we like.
She transfers the ownership of the property to the trust, which we create as, it's called a grantor trust. And the grantor trust status makes the income tax ramifications of the assets owned by the trust reportable on the transferor's, the wife or the mother's personal income tax return. So as a result of that that property for income tax purposes is still treated as her primary residence, reported on her return when it gets sold, and she still gets to use her $250,000 capital gains tax.
That's a beautiful thing. So now let's say, for instance, and I know the taxation of irrevocable trusts are pretty stiff. And what I mean by that is a married individual reaches the highest income tax bracket at about $750,000 of taxable income, and which is 37% on the federal side. An irrevocable trust hits it at 13,000. Okay, so the concern that I have is, let's say, for instance, she sells the property. Between selling the property and other assets from the life insurance and just other assets that she has, the trust is worth over $1 million. And let's say it's earning 4%, okay, which is decent from an income perspective. That's $40,000. If the assets are retained in the irrevocable trust, normally I think of irrevocable trusts, the trust itself pays the taxes, except if the assets are distributed. In this case, when it's a grantor trust, if it earns $40,000, but the assets are retained by the trust, are they still taxed to her or are they taxed to the trust?
The grantor trust status makes it taxable on her personal return. And
So
so
that's
any income from the trust assets will be reportable on the personal return of the grantor. And so that is generally, when we're doing this planning, a huge tax savings.
Which is another term that I say it's a beautiful thing.
It is.
Okay, because we love being able to find ways. So really, this particular trust provides a tremendous amount of tax advantages. It provides a tremendous amount of protection. What are the downsides?
So usually the hurdle that we confront as people are considering doing the planning revolves around their willingness to give up their own ownership and control, and basically the trust in their child or children that they're putting in charge of the irrevocable trust, because they're transferring ownership of these assets, real estate, bank accounts, stocks, investments, into the trust now. The only way for us to get the treatment we want for Medicaid purposes, which is for these assets to be disregarded, is for them to give up complete ownership and control. So when they get transferred, they go into this trust, they're naming someone else to be in charge. They're called a trustee. That's frequently a child. It can be multiple children if they want. But they are basically relying on those individuals to make good investment decisions, hold on to real estate if that's the intention for the family, for the parent to still stay there and live there and not like sell it out from under them. I will usually do certain things that might help to eliminate some of that fear, like a life estate or a long-term lease or something like that, to solidify their ability to remain in the home. But generally, they still have to trust these people. And just like everybody else, people like to hold on to their own money, and they like to be able to make their own decisions and feel like it's theirs until the time they pass away. So that's what people are grappling with: turning over control, giving up the ownership, and putting other people in charge. That's the number one worry. Other than that, from a pure planning perspective, it's a home run. Like, there's very little, I can't even really think of downsides on the planning from a tax perspective, asset protection perspective, probate avoidance. You get all kinds of benefits. But I've definitely had clients who have said to me, I get all that, sounds great, but I'm going to hold on to this money till I die. And it's mine. And if there's nothing left, I don't care. So basically, it's a worldview issue. And I do recognize that. And, part of me feels like the people who have decided that have done it with their eyes open. And their feeling is, I'd rather die with control over these assets. And that's more important to me than transferring them and getting these savings for the children or other beneficiaries.
Yes, and I can see that. And, the thing that I personally don't like about irrevocable trusts is that irrevocable word. I don't like I like flexibility. The term irrevocable is the exact opposite of flexibility as it pertains to irrevocability, right?
Right.
Yeah.
So this is a great breaking point.
Okay.
What were you going to
I
say?
was just going to add, when it comes to the notion of flexibility, when we talk about irrevocable trusts, we do really think, yes, they are irrevocable. They can't be changed. And for the most part, that's true. But we do like to draft these kinds of trusts to provide future flexibility. If there is a change in the law, if there is a trustee who has gone rogue and done something that they shouldn't be doing, we like to include what's called a trust protector that has a lot of different powers to be able to respond to those sorts of situations, so that there isn't this rigidity long term. If there is something that has to be changed, like I said, if it's a change in the law, it's a trustee, and doing that outside of a court process that's time consuming and expensive. So there is a way to provide some flexibility. By their very nature, irrevocable trusts, they provide these benefits because certain things are intended to be irrevocable. But you are not stuck with maybe what somebody might consider a bad trust if there's been a change in circumstances.
That's great. Well, thank you for adding that. We're going to come back. Stay tuned. We'll be back with you in just a few moments.
Do you keep up regularly with your investments? Where exactly are your hard-earned dollars going? Are you financially prepared for an emergency?
I'm Mike Menninger, founder of Menninger and Associates Financial Planning. We believe that education and knowledge are powerful, and we want our clients to understand why we are making the recommendations that we make. It's your money, and you deserve to know where it's going, because it's not how much you make, it's how much you keep. So call us today to discuss your financial concerns. Welcome back to Financial Planning Explained, and thank you again for Doug and Anylise to join me as we're talking about asset protection trusts. And we were using the example of the client that I had last night, and we talked about all of the advantages and obviously the disadvantages, that word that I don't like, irrevocable. But again, you pointed it out, it is something that the owner has to make a conscious decision. And I can see also there being some type of in-between thing. You say, look, I'm going to put a bunch of my assets in the trust, but I still want to have some level of control over a certain amount of assets to kind of hedge both sides. Yeah. Okay. But you referenced the rogue trustee. Let's now talk about the different roles. In this particular example, I've got 4 children. Okay. But it doesn't matter whether it's 2, 3, or 10. Okay, they're considered the beneficiaries. And correct me if I'm wrong, when the owner, not the owner, but when the individual, in this case, the mother, when she dies, then the trust basically gets dissolved and poof, it gets distributed to each of the 4 children, correct?
I did.
Potentially to them outright. It could go to them in further trust, but yes, there would be a share for each of the children. Typically, it'll really be up to mom to make the decision.
Right.
That person that's creating and funding the trust is called the grantor or
Right.
the settlor. Yep.
At which point she has, and we talk about this all the time when we're talking to our clients, he who is the maker of the trust within some guardrails has the ability to define the terms of the trust.
Correct.
Okay. So now you reference it could be one trustee, it could be multiple trustees. Share with me reasons why you would or would not pick one trustee versus multiple.
So it comes down to you're really threading the needle between wanting to have kind of a check and a balance between trustees and wanting to have administrative simplicity and ease. And so if you have one trustee that's acting, they have this unilateral decision-making authority and just the ability for filing tax returns and doing that sort of thing. They're signing all of that. They're just handling it on their own. There's not anybody else to check in with, talk to about making distributions. They're just running the show.
Mm-hmm.
And so that's easier from a logistics standpoint. If you have co-trustees, they have to check in with each other. One trustee is not able to do something without the approval and the sign off of the other trustee. And so that sometimes is attractive, but that does mean that every time something has to be done, both of those trustees are having to be involved in that process. And that sometimes is a positive in the viewpoint of some clients. They like the check-in. They don't care if 2 people have to sign off on everything. They prefer that. And for others, that feels like it's burdensome and they want to avoid it.
It reminds me of accounts that are established as and versus or. Okay, what you're telling me is that in a co-trustee environment, and requires both, or requires either or. Can it be constructed as it's either or?
It's always going to be and if there are co-trustees.
Okay.
So that might be a little bit of an oversimplification. We have a directed trust law in Pennsylvania. I feel like that's a little beyond the scope of what we're talking about today, but typically co-trustees are acting together.
Okay, that's fair. And so one of the things that I had said to them, so if you have a rogue trustee, whether it's one of the beneficiaries or not one of the beneficiaries actually have a legal recourse to go after the trustee if, in fact, it's proven that they're taking the money and using it not for the benefit, the intended benefit, correct?
So the trustees have a fiduciary duty to the beneficiaries of the trust. So obviously, they have to maintain the assets in a way that would be appropriate, invest them properly. They can't favor themselves because they have this responsibility to the other beneficiaries. But never want to find yourself in the position where you actually have to sue that trustee and go after them. That's a very expensive process. So trustee selection is a huge part of what we're looking at as we're deciding to do this kind of trust planning. We want to make sure that we're appointing the right person or people to fill the role and responsibility. And the responsibility that Anylise had brought up, which is the trust protector, also plays a role here because we typically will appoint a trust protector who'd be somebody who's a non-beneficiary who would have the ability to remove and replace the rogue trustee if they find out that these things are happening. So basically, we build in this remedy where the other children in the scenario that you painted would go to the trust protector and say, hey, this is what's happening. We feel like so-and-so is acting as trustee and they're doing things improperly. Can you look into it? And then the trust protector would have the authority to obviously determine if what they're telling them is accurate. And if they find that that's true, they can remove the trustee and then replace them with someone else to fill the role. Now, damage might already have been done. So depends on how far down the road the trustee had gotten as far as taking assets and investing poorly or doing whatever it was that they were doing wrong. But, you take that risk anytime you put somebody in charge. You
of course
have to pick the right person up front. But the trust protector is there with the idea of being able to get out of that bad situation.
So do you typically name, like for yourselves, are you as the firm drafting these documents often name yourselves as a trust protector if asked for by the client? Can you do that?
Like that. Yeah, it's something that a lot of clients ask us to do.
Okay.
That role is a non-fiduciary role as we write it into the document. So basically if we're filling the trust protector role or anybody, they don't have everyday responsibilities related to the trust. And I'd say overwhelmingly, the trust protector never gets involved and never is needed. And it's just written into the document as an insurance policy.
Yep.
And so I don't want people to think, oh, we name this trust protector and the attorney's in the document and they're going to be looking over our shoulder and checking on what we're doing and all that kind of stuff. It doesn't work that way. The trust protector is simply written into the document. And if somebody, trustee, beneficiary, person who's involved in things needs the help of the trust protector and the trust protector's powers are such that they'll be helpful in the scenario, they go to the trust protector and say, hey, this is what's happening. Can you help us out with that? And then the trust protector steps in based on their request, not on their oversight.
So can the trustee be one of the beneficiaries?
Yes.
Okay.
That is common. In a situation like this, people most frequently want the family members to be involved. Ease of administration, low cost. Usually they're not charging a fee.
Right.
A lot of people ask, well, what's the ongoing cost associated with managing one of these trusts? Really, it's very little because if you do have a family trustee, they usually don't charge a trustee fee. And a lot of people think initially every time there's a trust, there has to be some sort of professional or corporate trustee who's filling the role as trustee. That's not the case. You could have just a single family member handling the role as trustee. You could have a corporate trustee if you want it, and we've had clients decide that that's what they want. But I just want people to know that they don't have to, and they could have a single beneficiary
right
who is also the trustee.
Sounds costly. So, what are the costs? I mean, as far as I know, there's the cost to establish the trust. It's getting the attorney to prepare the trust. And then on an annual basis, they need to get taxes done, right? Because it's an irrevocable trust. It takes on, you have to go get a tax ID number. And now you need an accountant, $500, whatever it's going to cost per year to do the taxes on the trust.
Yep, pretty much the annual expense. I mean, if you had a trustee who was charging a fee, which again is rare, whatever that fee would be. But if we have the family member trustee, they usually waive the fee. The only other expense is really just the filing of the income tax returns on an annual basis. Other than that, it's just a separate legal entity with accounts or real estate holdings that are managed separately from individually owned assets of all of the different players that we're talking about.
So as I frequently overstep my bounds, in my conversation with the clients last night, the 4 children were there, I said, look, one of the things that you can do when we were talking about trustees, I said, it's very simple. I said, let's say, for instance, I am managing the assets inside the trust. And if the mother needs something, let's put it into the perspective, the trustee can take $20,000. I'm using that as an example. Effectively, the trustee can take the $20,000 out of the trust and use it for the mother's needs, correct?
We want to be really careful about that because the trust is drafted specifically to not benefit mom in our scenario.
Okay.
So the beneficiaries are likely the children.
Yes.
We don't want mom to have an ongoing connection to the assets of the trust. If she does, you don't get all of those benefits. You haven't given them away to the trust. You don't have the asset protection. It's considered a countable asset if she needs to qualify for Medicaid. So we want that separation. So you would never make a direct distribution from this kind of trust back to mom.
Okay.
But you could make distributions to the lifetime beneficiaries who are probably the children.
Mm-hmm.
Sometimes people will include grandchildren as well. So you could make a distribution to that lifetime beneficiary who is not mom, and then they could choose to use that distribution to benefit her.
Fair enough. We're saying the same thing, but it's semantics, but they could do that.
Yeah, the assets aren't permanently locked up and kept away from everybody and inaccessible. There is still the ability, if other assets outside of the trust are depleted, the assets are accessible to be able to help mom if she needs it.
Fair enough. And so this is where I was potentially overstepping my bounds, but I don't think so. Because one of the things that I said to them, I said, look, anytime anybody wants to grab money from any account, okay, the trustee has the power to do that. The thing that I say is, look, it's very simple. Anytime anybody needs money from any account, depending on the time of the day that they ask, it's going to be either 2 or 3 business days before the money is actually released. I said, I could easily have an agreement with you that if the trustee calls me and asks me for money, that, okay, you got 2 days before the money is actually received. I very simply reach out for their email or whatever to all of the other beneficiaries and say, hey, so-and-so is looking to take 20 grand out of the trust. Are you guys okay with that? Am I overstepping my bounds by saying that?
You would want to have that appropriately documented, that there would be trusted people on the actual accounts. And this would be more in your wheelhouse than mine. The financial institutions will allow you typically to name like a trusted individual.
Mm-hmm.
And so you may want to structure it where those accounts that are held by the trust, these trusted individuals are the other beneficiaries.
Well, in this case, it's the same beneficiaries. I'm just noting that if the trustee is one of the 4 beneficiaries, they're not just taking money out roguely, that it's just like my notifying the other 3, hey, the trustee is taking money out, just letting you know. And if there's an issue.
I don't think you would be overstepping. I'm just saying, I think you would want to just document it appropriately.
Okay. Fair enough. Now, you also pointed out that, tell me the common uses. And this was an example of one, but you had referenced there's common uses of these trusts. Can you lay them out? Because guess what? We're already at the end of the time.
Getting close. I'd say the most common demographic of individuals would be individuals in their late 60s to early 80s, with assets probably somewhere in the $500,000 to $2 or $2.5 million asset range. Usually a house, brokerage, IRA, maybe some other real estate, sort of that typical profile, with obviously an overarching goal of protecting those assets from the nursing home spending. So a goal to make sure that if they do need that long-term care, that the assets they have are not vulnerable to the spend down process because of the rising cost of that kind of care. So a lot of us have family members that we've seen go through that, and we have been somewhat scarred by it. And we want to make sure that those assets that we have are protected and we don't have the same kind of thing happen. So I'd say that that's sort of the demographic that we see most frequently. People who have assets in excess of that can do the planning. It's just that they're usually just that much more reluctant to give up sufficient ownership and control over their assets to make it worthwhile for what this kind of trust planning is for. So that's why I think less frequently will you see individuals. People in that $500,000 to $2.5 million range are the ones that could get hammered by this at $20,000 a month, to $140,000, $150,000 a year. That can really put a dent into the assets they were planning on passing along to their beneficiaries.
We threw a curveball in there when you referenced IRAs. A trust by rule is an entity, and an entity cannot own an IRA. That's number one, which I know we've used you to establish trusts that can handle that. But the second component of it is that if I'm thinking about Medicaid planning, the IRAs have RMDs, required minimum distributions, for those of you. Once you reach a certain age, now it's 73, it'll be at 75 in 2033. But how do you address that from a perspective of not having money for Medicaid if there's an IRA in there that's distributing required minimum distributions? What do you do?
Well, the IRA is a tricky one, very difficult to deal with as it relates to the Medicaid planning because individuals cannot gift their IRA to anybody else or into trust for someone else. The decision making there is, do they retain the IRA and then maybe transfer ownership of more or less everything else?
Yeah, all right.
And then the IRA is the portion of the overall assets that they retain to spend and pay for things for the balance of their lifetime. And then only as they're taking the money out are they going to trigger the income tax implications. Alternatively, if you really felt strongly that you wanted to protect those assets, you'd actually have to withdraw them from the IRA, pay the tax, and then transfer the after-tax dollars to the trust. So people are usually loath to get that big tax bill underway. So maybe they just make a little bit more aggressive withdrawals over time. And then some of our clients from a strategy perspective who have transferred large portions of their other assets like real estate and other financial assets retain the IRA and use that pretty much as their sole means for spending. So they're pulling from it more aggressively with the idea of whittling that away so that ultimately if they did need care, that IRA would have dwindled down and there would be far less vulnerable than when they did need the nursing home care at some point in the future.
Well, even if they use the IRA for the nursing home costs, that's buying them time for the 5 years for the Medicaid spend down, for one. For two, if they're truly in a nursing home and they don't have long-term care insurance, which if they have long-term care insurance, we don't need the protection. But the interesting part about it is that the IRA, while it's taxable income, if it's being used to pay for the nursing home costs are going to be a tax-deductible item on Schedule A, which means that a lot of those IRA taxes are going to be offset by the tax deductions. So is there anything else you want to add, because we're already beyond our time?
I mean, I think we've gotten a good summary of things. There's a lot more to talk about.
There is.
We could not fit it in the next 2 or 3 minutes, so we won't even bother to try.
Well, we're past that. So I wanted to thank Doug and Anylise. Why don't you do me a favor and take a moment, look in the camera, tell a little bit about yourselves, the company and the firm, and how people can reach you.
Yeah, absolutely. Thank you, Mike, so much for having us join you today. I love this planning. We get really excited to be able to have the opportunity to talk about it and share it with people. We are, as Mike said, with Unruh, Burke Frees. We're in the Trust and Estates and Wealth Preservation and Elder Law group. And this is the only type of work that we do. We are focused strictly on trust and estate planning, trust and estate administration, and this elder law work. So we live it, we breathe it, we love it, and we'd be happy to connect with you to talk about your particular situation. All of our contact information is going to be up on the screen, so reach out to us anytime. And Doug can tell you we have multiple offices here in Pennsylvania. So.
Yes, we are a multi-practice firm, but Anylise and I are part of the specific practice area that deals with just the elder law and estate planning and estate administration work, helping individuals do their planning to make sure that their loved ones are protected in all kinds of different ways. But we do have attorneys throughout the firm doing other work and are happy to put people together with them as well. We have offices in Phoenixville, Pennsylvania, and also in Westchester, Pennsylvania, but we meet with clients throughout the state of Pennsylvania by Zoom or teleconference. So we're happy to help people throughout the state.
Thank you very much. Well, so I hope everybody had gathered some information today, can apply it to themselves or somebody they know. And please, you know what? I encourage you to look for Doug and Anylise because those are the best estate attorneys that I've ever come across. So thank you for joining us and have a wonderful day and a wonderful week, and see you again on Financial Planning Explained. And if you ever wish to reach us, our phone number is 610-422-3773, or you can check out our website at www.maaplanning.com. Thank you and have a great day.